Hello friends, today we will start from Evidence Act documents. I will request everyone to open your book and find the definition document. I am reading. Document means any matter expressed or described upon any substance by means of letters, figures or marks. Not every word. Document means any matter expressed or described. Either it is expressed or it is described. The words or images or anything written on the caves or any stone, that is also a document. By means of letters, figures or marks. So the expression or description may be made by use of letter, image or marks. Any marks, or by more than one of those means. Either any of these, that means expression, description or marks, or more than one, intended to be used or which may be used for the purpose of recording the matter. So there are few ingredients. Documents means any matter expressed or described. Either it should be expressed or it should be described. This is the ingredient number 1. Ingredient number 2, it should be expressed or described by use of letters, figures or marks. Any one of these or more than one of these. And the ingredients number 3, it should be intended to be used or which may be used for the purpose of recording that matter. So the letter, figure or marks should be intended to record a particular matter. So anything written on paper, anything written on stone, anything written on the caves, all these are documents if these are expressed or described by means of marks, letters or figures and for the purpose of recording the matter. In this matter, Supreme Court in a judgment held that CD is a document. Why? In a CD, when we write a CD, we write some marks, digital marks in the CD. What is the purpose of that? It is the purpose to express or describe anything, any matter. So the CD is itself a document. Now there are a few illustrations in the Evidence Act after the definition of document. I am reading, please follow. A writing is a document. It's very normal, we know it very well. Now the most interesting, words printed, lithographed or photographed are documents. So if a photography, a picture, a photo is also a document. Why? It is intended to express or describe something. Photograph of a marriage. What is the purpose of that particular photograph? Purpose of that particular photograph is to show, to record the marriage ceremony. Say Saptapadi, recording of that marriage. How it is done? It is done by use of some marks, some figures. When we capture a photo digitally, or in earlier age we used to take photo on our films, negatives. All these are recording of a particular incident, particular matter. We used to use some sort of marks or figures, and the purpose of these marks or figures are to describe a particular incident, and the another purpose is to record the incident, to record the matter. So a photograph is also a document. Similarly, lithograph. A map or plan is a document. A building plan. What is the purpose of the building plan? How the building structure is. Where is the column, where is the beam, where is the lintel, and all these are designed by figures, marks, etc. The purpose is to describe the infrastructure, to describe the structure of a building. And another purpose is to record the structure of the building, the map. So it is a document. Another, we find in many cases, in criminal cases, where along with the charge sheet, police submits a map of the place of occurrence. Say a murder case. A murder has committed by someone in some village in a tea stall. Police visits that place, draws a map of that particular area showing the place of occurrence, north, south, east, west, the neighborhood buildings or stalls or whatever. All these things are described by way of a map. This map is also a document. An inscription on a metal plate, stone is a document. I discussed the matter of the stone. Similarly, is metal also. Say, there is a metal coin of Samrat Ashok's age, having a photo inscribed over it of Samrat Ashok, and a year is mentioned below. It is a document, and it shows that this particular coin was in use during the era of Samrat Ashok, and the coin was issued, manufactured in that particular year. So a inscription on a metal or stone is also a document. A caricature is also a document. It is very simple. Now, without prolonging this thing, I am coming to the next point. Evidence. We are discussing about the Evidence Act. So we should learn what is evidence. The next definition is evidence. Please read with me. Evidence means and includes, number one, all statements which the court permits or requires to be made before it by any witnesses in relation to matters of fact under inquiry. Such statement is called oral evidence. So the first thing is all statements which the court permits or requires. Either court permits it or court asks for it, demand it, give directions to produce this thing. Requires to be made before it. So evidence to be adduced, evidence to be made before the court. By whom? By witnesses. In relation to matters of fact under inquiry. So everything is not evidence. Evidence should be that particular thing which is given before the court. Either court permits it. If it is not permitted by court, then it is not evidence. Or court requires it. Court asks someone to produce that particular piece of thing before it. That is to be treated as evidence. And what is the another basic character of evidence? It should be related to the matters of fact under inquiry. Note it, not inquiry, but the spelling is inquiry. INQUIRY. This statement, when it is statement, it is called oral evidence. And all documents, including electronic records produced for the inspection of the court, such documents are called documentary evidence. What is stated before the court, that is oral evidence. And if any document including electronic records, that may be CD, that may be a hard drive, that may be pen drive or anything else, whatever, that is called documentary evidence. So there are basically two types of evidence: oral evidence, documentary evidence. And what is the basic character of evidence? Number one, it should be given before the court. It should be either permitted by the court or it should be required by the court. It should be given by the witness. And the last one is, it should be related to the matter under inquiry. In a case of dacoity, any statement related to Aadhaar card forgery will not be a matter related to the inquiry. So that statement will not go under the heading evidence. Now I am coming another most interesting thing: proved, disproved and not proved. I am reading. Proved. A fact is said to be proved when, after considering the matter before it, the court either believes it to exist or considers its existence so probable that a prudent man ought, under the circumstances of the particular case, to act upon the supposition that it exists. It is very simple, but it is very difficult. I am explaining it part by part. A fact is said to be proved when, after considering the matters before it, the court either believes it to exist. Court thinks. A court, after considering all the matters, all the things placed before it, court either thinks that this particular matter, this particular thing is in existence, or considers its existence is so probable that a prudent man ought, under the circumstances of the particular case, to act upon the supposition that it exists. Either court have to believe that it exists, or court has to believe that its existence is so probable that a prudent man a prudent man ought, under the circumstances of the particular case, to act upon the supposition that it exists. I am giving a small example. Mr. X fired from his pistol to Mr. B, and Mr. B died. It is proved that Mr. A was in possession of a pistol. It is proved that Mr. B died out of the injury, bullet injury. And it is also proved that Mr. A and Mr. B was nearby, close by. And eyewitnesses also proved that Mr. A aimed his gun to Mr. B with the threat that I will kill you. So here the court can believe that it exists, or there is every probability that a prudent man ought to believe in these particular circumstances that it exists. What? That there was bullet in the pistol. The bullet found in the head of B, due to which B died, was in the pistol of Mr. A. In the particular circumstances, in the particular case, any prudent man will assume its probability of existence. Existence of what? That the bullet found in the head of Mr. B was in the pistol of Mr. A. So it is proved. Either it should be beyond doubt, or it should be so probable that any prudent man will consider its existence in the particular case. Now the next point is disproved. A fact is said to be disproved when, after considering the matter before it, the court either believes that it does not exist, or considers its non-existence so probable that a prudent man ought, under the circumstances of the particular case, to act upon the supposition that it does not exist. Just opposite to the definition of proved. Court either believe that it doesn't exist, or after consideration of the entire matter, court believes to the non-existence so probable that a prudent man ought, under the particular case, to act upon the supposition that it does not exist. So till now we discussed proved and disproved. Proved means it is proved. Disproved means it is placed before the court, but court denies to admit it, to consider it as proved. So it is disproved. Now, what is not proved? A fact is said to be not proved when it is neither proved nor disproved. Though the two words disproved and not proved sounds very similar for any common person, but we, the student of law, know that these two terms are not at all similar. There are lots of differences between these two words. Disproved means it is placed before the court and court denies to accept its existence. So it is disproved. And not proved means neither it is proved nor it is disproved. So the matter doesn't come before the court. While Mr. X fired upon Mr. Y from his pistol, Mr. Y was eating biscuit. So a packet of biscuit was in the hand of Mr. Y. But that particular fact that at that particular point of time Mr. Y was eating biscuit, there was a packet of biscuit in the hand of Mr. Y did not come before the court. So this particular fact that Mr. Y was eating biscuit at that particular point of time is neither proved nor disproved. Sorry. It is not proved. I think I could clear these three very important definitions of evidence. I am once again telling you all to write to me directly to my email if you have any confusion, and I will be very glad to reply your emails. Now section 4. Another three very interesting definitions of Evidence Act. May presume, shall presume, and conclusive proof. I am reading may presume. Read with me. Whenever it is provided by this act that the court may presume a fact, it is either it may either regard such fact as proved unless and until it is disproved, or may call for proof of it. In many cases, in many sections, In many sections, in many provisions, we will find later and in other enactments, the court shall presume, the court may presume. These two words. May presume means whenever it is provided by the act that the court may presume a fact, it means the court. It may either regard such fact, which fact is mentioned as court may presume. Court may either regard the fact as proved without taking any evidence. Court may regard that fact as proved because in the section, if in the section the word may presume is there, unless and until it is disproved. If that particular fact is disproved by way of evidence, then court cannot take that presumption. Otherwise, court may take the presumption that the fact is proved or may call for proof of it. So, whenever in any provision we find that the word may presume is mentioned, then and there we should make it in our mind that in this particular matter, court may regard this particular fact as proved unless and until it is disproved, or may call for evidence for it. So court has two options. If the word may presume is mentioned, the court has got two options. Option number one, court may regard the matter as proved unless and until it is disproved. Court can do this. Number two, alternatively, court may call for proof of it. Court may ask either of the party to submit proof by way of evidence. So this is may presume. Now I am coming to shall presume, the very next one. Whenever it is directed by this act that the court shall presume a fact, it shall regard such fact as proved unless and until it is disproved. Where is the difference? Where is the difference between may presume and shall presume? In shall presume, whenever in any enactment or provision the word shall presume is mentioned, that means it is the mandate upon the court to regard such fact as proved unless and until it is disproved. So when may presume is mentioned, there court has got another extra option. What is that? Court may ask for proof of it. But when shall presume is mentioned, court has not any option. Court has to regard this fact as proved unless and until it is disproved. Court cannot ask for any proof of it. And the third one, conclusive proof. This is the last part of today's discussion. I am reading. When one fact is declared by this act to be conclusive proof of another, the court shall, on proof of one fact, regard the other as proved, and shall not allow evidence to be given for the purpose of disproving it. It is a little bit confusing. I am elaborating. When one fact is declared by the act to be conclusive proof of another, if fact number A is proved, this proof of fact number A should be treated as conclusive proof of fact number B. In that case, court shall not allow evidence to be given for the particular purpose of disproving it. So in any particular provision, it is mentioned that if fact number A is proved, then such proof of first fact number A shall be the conclusive proof of fact number B. In such scenario, court has got no other option but to treat fact number B as proved, and court has got no power to allow any evidence to be adduced before it to disprove the fact number B. So, a small summary of may presume, shall presume, and conclusive proof will be very helpful, I think, for you. In may presume, court may regard the fact as proved unless and until it is disproved, or may ask for proof of it. In shall presume, court has to regard that particular fact as proved unless and until it is disproved. So when in may presume, court may ask for evidence. In shall presume, court has got no power to call for any evidence unless and until it is disproved, it is proved. And in conclusive proof, if one fact in any provision, it is mentioned that one fact should be treated as the conclusive proof of the another, court, upon proof of the first fact, have to treat the second fact as proved and has got no power to call for any evidence for it. Now, while I was discussing, there were various slides, and I have also given a distinction between proved, disproved, and not proved. I think one or two case reference will be highly helpful for you. In this regard, I want to mention M. Narasimha Rao versus State of AP. Please see the sliding. M. Narasimha Rao versus State of AP, AIR 2001 SC 318. In this case, Supreme Court held that proof does not mean proof to rigid mathematical demonstration, but such evidence as would induce a reasonable man to come to a conclusion. Proof means not in strict sense like mathematical conclusion, but such evidence as would induce a reasonable man to come to a conclusion. It depends upon degree of possibility of having existed. Proof always should not be like a mathematical description, mathematical demonstration, that a particular answer, after applying all these formulas, a particular answer will come. But it should be, proof means it should show such possibility, probability that it exists. The next very interesting case is Chaturbhyug Pandey versus Collector of Raigad. Supreme Court held that under section 3 of the proof or disproof of a fact is to be tested on the touchstone of belief of the court or probability or otherwise of a prudent man. There is no standard by which the weight of evidence of the parties can be ascertained. So there is no standard, there is no thumb rule, there is no formula. Instead of West Bengal versus Orilal Jaiswal, Supreme Court held that proof is the effect of evidence. It is considered with establishment of material facts in issue in each particular case by proper legal means to the satisfaction of the court by evidence, admissions, presumptions, judicial notice, etc. Such proof does not mean rigid, again, Supreme Court puts very stress upon this particular phrase of word. Such proof does not mean rigid mathematical demonstration, but it must be such as would induce a man of ordinary prudence to come to a conclusion. So this is the end of today's discussion. I think I could explain up to this part to you properly. I will request you to send me email, or you may get in touch with me over phone for any confusion, for any question, and I will highly appreciate all kinds of suggestions from you to improve these lecture sessions. After my previous session, I received some emails from you, and I am very much thankful to all of you for giving me such valuable suggestions. Thank you. Stay blessed.